Understanding the Jones Act, what it is, who qualifies, and what you can recover. Welcome back to Ask Rusty Law. I'm Rusty Messer, an attorney with Big River Trial Attorneys. Today, we're talking about the Jones Act. And if you work on the water, this episode is for you. So you've probably heard that term if you work on a vessel, a tugboat, an offshore supply boat, or in any part of the maritime industry. But a lot of workers don't fully understand what it is, whether it covers them, or what they can actually get out of a Jones Act claim. So that's what we're going to break down today. So we'll cover what the Jones Act is, who qualifies as a seaman under the law, what you can recover if you're injured, and how the Jones Act compares to the Longshore and Harbor Workers Compensation Act, the LHWCA, which is a different federal law that covers a different group of maritime workers. Let's get into it. The Jones Act, it's formally part of the Merchant Marine Act of 1920. It's a federal law that gives maritime workers, called seamen, the right to sue their employer for injuries caused by negligence. And so that's the core of it. Now, why do we need a special federal law for that? And that's because seamen are in a completely different legal category than land-based workers. If you get hurt on a construction site or in a factory in Louisiana, you will file for a state workers' compensation claim. It's a no-fault system. You don't have to prove anybody did anything wrong. You just have to show you were hurt on the job. But seamen, they generally can't use state workers' comp. So maritime employment falls under federal law, and the Jones Act is the primary way an injured seaman can recover damages from their employer. And without that, you would largely be on your own. Congress created the Jones Act specifically because seamen work in dangerous conditions. Like they're far from shore. Often they don't have easy access to medical care. Congress said, hey, these people need legal protection that matches the realities of their working conditions. And the Jones Act does a few key things. It gives injured seamen the right to bring a negligence claim directly against their employer. It also comes alongside two other major maritime rights, maintenance and cure and unseaworthiness. We'll get into those in a minute. So who qualifies? Who actually qualifies under the Jones Act? This is probably the most litigated question in all of maritime law. And the answer is not always obvious. So to be protected by the Jones Act, you have to qualify as a seaman. And I want to be clear, you don't have to be a sailor or a ship's officer to be a seaman under the law. The legal definition is broader than that. So courts are going to look at two things. They're going to look at your connection to a vessel and your job duties. So the general standard is that you must spend 30% of your working time aboard a vessel in navigation. That vessel has to be afloat, has to be operating, and on navigable waters. It can't be sitting in a dry dock getting repaired. It has to be in service. And your work has to contribute to the function or mission of that vessel. So virtually all of the crew members, the captains, they're going to qualify. But somebody who's just occasionally there, maybe like an office worker or an administrative employee, probably will not. Let's take a second to talk about navigable water. The term navigable water is a complicated issue. It typically refers to water that goes out to the sea. So this would include rivers and even some lakes, as long as you could get to the sea from there. It does not include completely landlocked bodies of water like some lakes and reservoirs. It may not include some bodies of water that can lead to the sea if the waterway can't be used for commercial operations. All right, let's go back to talking about who qualifies. So here's a list of workers who commonly qualify as Jones Act seamen. So you have crew members on cargo ships and tankers. You have tugboat and towboat workers, offshore supply vessel crews, commercial fishing crews, captains and officers of any vessel in navigation, some oil platform workers, but this one gets complicated. All right, that last one, oil platform workers, is where it gets tricky. If you are working on a fixed platform that's permanently attached to the seabed, you are generally not covered by the Jones Act. Fixed platforms are not considered vessels. But if you're working on a floating rig or a drill ship, or maybe like a semi-submersible, something that can move on the water, that may qualify as a vessel, and you may qualify as a seaman. That is exactly why you need to talk to an attorney who knows maritime law. The line between vessel and fixed platform has been litigated all the way to the U.S. Supreme Court, and getting that determination wrong can cost you your claim. So let's say you qualify as a Jones Act seaman and you've been injured on the job. What can you actually recover? This is where the Jones Act becomes very powerful. So under the Jones Act, there are three main areas of recovery available to injured seamen. You can bring a negligence claim, an unseaworthiness claim, and you can get maintenance and cure. So let me walk you through each one of those. So the Jones Act negligence claim lets you sue your employer directly if their negligence played a part in causing your injury. And I want to emphasize that it's any part, even a very small part. Courts use what is called a featherweight causation standard for the Jones Act. So under ordinary personal injury claims, you have to show that negligence was a substantial cause of your injury. Under the Jones Act, you only have to show that it played some role, even a minor one. And that is a much easier standard to meet. And look, negligence can take a lot of forms. Let's say a crew member you're working with is not properly trained. Maybe you're working on equipment that wasn't properly maintained and it malfunctions. Maybe there's a slippery deck issue that wasn't addressed. An unsafe work order. Maybe they didn't give you the right safety gear. Just the general failure to provide a safe place to work. Any of these can form the basis of a Jones Act claim. And if you win a negligence claim, the damages available look more like a traditional personal injury case than they do like a workers' comp case. This means you can recover past and future medical expenses. You can get past and future lost wages. You can recover for your loss of earning capacity, your physical and mental pain and suffering. You can get mental anguish. And there is no cap on the damages under the Jones Act. That is a significant difference from workers' compensation or the LHWCA, both which limit you to a percentage of your wages and your medical bills. One more important note, if you were partially at fault for your own injury, that doesn't bar your claim. The Jones Act uses a pure comparative negligence standard. So your recovery will get reduced by your percentage of the fault, but you can still recover something even if you were partially to blame. All right. So you have 3 years from the date of your injury to file a Jones Act negligence claim. But don't wait, because the sooner you bring your claim, the better it will be for your case. All right. Separate from the Jones Act itself, but almost always pursued right alongside of it, is a claim for unseaworthiness. This comes from the general maritime law, and it's a different form of negligence claim in an important way. Under the doctrine of unseaworthiness, the vessel owner has an absolute duty to provide you with a seaworthy vessel. That means the ship, all of its equipment, all of that, and its crew are reasonably fit for their intended purpose. If any of that's deficient, so if they give you faulty equipment, if they give you broken ladders, inadequate PPE or safety gear, even if there's a crew member that's known to be unfit or a danger, the owner can be held liable. The key here is that unseaworthiness doesn't require you to prove negligence. You don't have to show that the owner knew about the problem or failed to fix it. You just have to show the condition existed and it caused your injury. So that is a very powerful claim. In some cases of truly egregious conduct, where the owner was just recklessly indifferent to your safety, courts have also awarded punitive damages on top of everything else. These are punishment damages just because of the owner's actions. All right. The third protection is called maintenance and cure. And this one is unique to maritime law, and it's available to you regardless of fault. You don't have to prove anybody did anything wrong. If you're injured or you become ill in the service of a vessel, your employer owes you maintenance and cure. Maintenance is daily living. It's a daily living allowance that covers your basic expenses, things like rent, utilities, and food. And this is while you're recovering or while you are unable to work. The daily amounts vary, but they're typically in the range of 30 to 65 per day. This kind of depends on your contract and what's customary in the area that you are working. And look, those numbers may sound pretty low, but the obligation continues until you reach what is called maximum medical improvement. So that's the point where you've recovered as much as you're going to recover. So in a serious injury case, that can take months or even years. And even though you're not getting as much as you would like, you can get something. Now, cure covers your medical expenses. Your employer has to pay for your medical treatment related to the injury until you reach that maximum medical improvement. All right, one more thing. If your employer unreasonably refuses to pay maintenance and cure, or they drag their feet on paying it, courts have awarded punitive damages in those situations too. It's not a benefit that employers can just ignore. Punitive damages we're talking about additional money designed to punish a defendant and to deter future conduct. Now let's talk about the Longshore and Harbor Workers Compensation Act, the LHWCA. So a lot of maritime workers get these two confused, or they don't know which one applies to them. So here is the short version. The Jones Act and the LHWCA are typically, they are mutually exclusive. So if you get one, you don't qualify for the other. They cover different workers. Even though they are mutually exclusive, sometimes you may need to file both claims to protect your rights until a court determines which one actually applies to you. So the LHWCA is a federal workers' compensation law. It covers maritime workers who are not seamen. So this means workers who are land-based or shoreside, but whose jobs support the maritime industry. We're talking about longshoremen, stevedores, shipbuilders, ship repair workers, harbor construction workers, and other workers on docks, piers, wharves, terminals, even shipyards. Basically, if you're working adjacent to a navigable waterway and your job is loading, unloading, building, or repairing a vessel, but you are not a crew member living and working on the vessel, the LHWCA is likely your remedy. So to qualify under the LHWCA, courts look at two things, the situs test and the status test. So situs means where were you injured? So it has to be on navigable waters or in an area adjoining navigable waters. So that's customarily, so waters that are used in vessel-related work. And status means that you do your job your job is deemed to be maritime in nature. So you got to pass both of these tests. And so let's talk about the practical differences between the Jones Act and the LHWCA. And there are a few important ones. One is fault. First, the Jones Act requires you to prove your employer was negligent. LHWCA does not. Like most workers' comp systems, LHWCA is a no-fault system. It hurt on the job, you're covered. You don't have to prove anyone did anything wrong. That makes the LHWCA benefits easier to access, and you typically get them faster. Second is what you can recover. And this is where the difference really matters. Under the LHWCA, you're looking at workers' comp type benefits where you're getting about 2/3 of your average weekly wage plus your medical expenses, but that's it. No pain and suffering, no mental anguish, no recovery of the full value of your wages. Or under the Jones Act, If you can prove negligence or unseaworthiness, you can recover the full picture. So 100% of your lost wages, both past lost wages and future lost wages. You get pain and suffering, you get mental anguish, and potentially even more. The difference in dollar value between a Jones Act claim and an LHWCA claim can be very significant. And third is maintenance and cure. This benefit is unique to Jones Act seamen. LHWCA workers don't get maintenance and cure. They get workers' comp benefits, which are structured differently and actually pays a little bit better than maintenance and cure, but they do not get maintenance and cure. Fourth is where your case is resolved. LHWCA claims go through a federal administrative process. It's overseen by the Department of Labor. The Jones Act claim can be filed in state or federal court, and you have the right to a jury trial. That matters enormously in how your case plays out. So the question of which law applies to you is not always simple. Your employer may tell you you're covered by one law when you're actually covered by another. That happens more often than you would think, and it can significantly affect your rights and your recovery. The law that applies to you is determined by the nature of your work, not what your employer says, not by what contract you signed. So don't take your employer's word for it. If you've been injured and you're not sure which law covers you, that's exactly the conversation you need to have with an experienced maritime attorney. All right, let's bring it all home. If you work on the water, so this is on a vessel, a tugboat, a supply boat, a drill ship, the Jones Act may be one of the most important federal laws that you've maybe never fully understood. It was built specifically to protect people in your situation because Congress recognized that maritime workers face risks that most workers never encounter. So if you've been injured, here's what I want you to walk away knowing. The Jones Act gives you the right to sue your employer for negligence with a lower burden of proof than like an ordinary personal injury law, like a car accident or a truck accident or something like that. You may have an unseaworthiness claim against the vessel owner, even without proving negligence. And you are entitled to maintenance and cure regardless of fault. So if you work on a dock, a pier, a shipyard, or anything like that instead of a vessel, the LHWCA may be your law, but the benefits and processes vary differently. If you'd like to know more about the LHWCA, we have an entire episode on that the link will be in the description below. Remember, you have 3 years to file a Jones Act claim, so do not wait. All right? Don't wait 3 years. Seems like a lot of time, but it passes quickly. Thank you for tuning in to this episode of Ask Rusty Law. Please remember to like and subscribe. Share this episode with anybody that you know who may need it. And if you have questions about the Jones Act, call an experienced maritime attorney. If you have questions about the LHWCA, make sure to check out the next video. And as always, stay safe and stay informed.